Thank you so much. Hi, everyone. I'm Carlin Corey. I am a group manager here at the National Laboratory of the Rockies. We are here and very excited to have a conversation about state tribal energy collaboration. This is the last in a series of webinars that we have done. We also had 2 in-person workshops and 6 fact sheets that were published. And this today will be around an introduction to tribal sovereignty and governance. Next slide, please. So those of us from the National Lab of the Rockies would like to welcome you to this webinar. I, again, am Carlin Corey. Allison Smith is the project manager. Emma Burkow is the researcher, along with Milena Pakes, another researcher. This project is funded by the Department of Energy's Office of Policy in coordination with the DOE's Office of Indian Energy. We put this program together because there was a realization that states are very interested in supporting tribes as they move forward with their energy goals and trying to achieve energy sovereignty. However, there hadn't been a lot of materials and resources put together to help states do that. So the Department of Energy answered that call and funded this program and project. Next slide, please. So before we begin, I am actually sitting on our campus, which you can see in the picture there. And we want to express our gratitude and acknowledge that the land our main campus is on in Golden is the traditional and ancestral homelands of the Arapaho, Cheyenne, and Ute peoples. We recognize and pay respect to the indigenous peoples from our past, present, and future. And we are grateful to those who have been and continue to be stewards of this land. We recognize that we work throughout the traditional territories of the indigenous peoples of Alaska as well. Our research and testing facility is located on the ancestral lands of the Lower Tanana River Dene people, and we acknowledge and honor the ancestral and present land stewardship and place-based knowledge of these people of those territories. Thank you. So if you are not familiar with the National Laboratory of the Rockies, which was formerly called NREL, or the National Renewable Energy Laboratory, this gives you a picture of where we're at. We have just below 4,000 workforce. We provide world-class research expertise in energy systems integration, transportation and fuels, buildings and industry, and particularly in storage and microgrids. We have partnerships with industry, academia, and government, and we have 4 campuses that all operate as living laboratories. We even sometimes get little polls about how is the temperature in your space, or have you tried this new technology? So it's kind of fun being part of the living laboratory. And then we work across not just the US, not just with tribes, but also other international entities. Next slide. NLR has partnered or supported more than 3,000 communities, tribes, jurisdictions, utilities, and businesses to achieve their energy goals through planning, technical assistance, capacity building, workforce development, and more. And you can learn more on our NLR website, which we will drop in the chat. Next slide. So this specific project was created, as I briefly mentioned, to identify and answer key questions about tribes, tribal energy support, and tribal energy issues, to identify ways for state governments and tribes to successfully collaborate on tribal self-determined energy goals. And as I mentioned, we have published 6 fact sheets. This is the last of our 5 webinars, and we conducted 2 in-person trainings, one in January and one in February. And really the goal is to help equip states so that they understand the tribal perspective and the tribal context. And you are really in for a treat today because we have two fantastic resources that are going to be giving you this webinar. So first, we have Margie Schaff. Margie is a partner at Native Energy Resource Counsel, LLC, where she represents tribes and the tribal organizations with tribal legal codes, tribal utility negotiations, electric power and transmission contracting, oil and gas, tribal energy resource development, business matters, and energy strategies. Margie has been an energy attorney for over 38 years. Margie also operates Schaff Martin Consulting, which provides technical assistance to the U.S. Department of Energy on Indian-related matters. Margie has also published law review articles, including Regulation of Electric Utilities on Indian Reservations and Indian Allotte Water Rights, a case study of allotments on the former Malheur Indian Reservation. Joining her today is Logan Big Eagle. He's a member of the Osage Nation and a partner attorney at Native Energy Resources Council. He spent his career exclusively representing tribes in economic development, regulatory development, and exercise in government sovereignty. So I will hand it off to Margie and Logan. Thank you so much for being here.
Well, good afternoon, everyone. Thank you so much for inviting us to be on this webinar. We appreciate our partnership with the National Lab of the Rockies, and we're excited to introduce this topic of tribal sovereignty and tribal governance as it relates to the energy industry to this new audience of people. First of all, I guess I'd like to just say that we do have the map of Indian country here. Obviously, the entire United States at one point was tribal lands. And so whether or not you have an Indian reservation in your state or in your area, there may be traditional Indian rights that still reside there, whether by treaty or whether by cultural or other laws that protect historic and cultural artifacts and so forth. Could we start with the first slide, please? So I would like to make this presentation fairly informal. So we're going to go through the first slide here, and then we will ask for questions. So please just raise your hand or go off mute if you have a question when we're done with this slide. So this presentation was developed to talk about the utility operations in Indian country and how states and other governments can interface properly with the tribes in their regions, especially as it relates to utility operations and the idea of who has jurisdiction over what. But of course, the discussion here can be applied to a number of other kind of related topics. So first, kind of to begin with, I'll just say that there has been a real substantial growth in Indian country's operations in the energy industry over the last 25 years. In part, this has come from the development of casinos, which has prompted, the building of new buildings and a number of other economic activities. So that kind of growth has led to a real growth in local tribal human resources and education. New infrastructure has been built, many new buildings, including the resorts and commercial buildings, agricultural buildings, also government and community buildings. And then, of course, as the population of Indian country has grown, there has been a much needed growth in the residential sector. Often these are HUD buildings, simply because of the land restrictions in Indian country. It's very difficult for most Indian people to build their own home. So oftentimes they have to be built by the tribe. There is a huge economic impact that comes along with this substantial growth. Indian tribes generally provide a really positive impact to the population surrounding the tribal lands, especially if there are resorts or casinos or other major businesses operated by the tribe. It's really important to understand that tribes are not just racial groups. Indian country is not part of some kind of a DEI movement. They are groups that are governments. They're in the United States Constitution as separate categories. Indian people have specific rights that are inherent to their sovereignty. They are also acknowledged in federal law and other laws. So tribes should not be considered as simple racial groups or as stakeholders by states. They are governments that have specific rights and are able to act upon them. So Logan, if you want to take the next topics here.
Yeah. Thanks, Margie. And hi, everybody. My name is Logan Big Eagle, and I echo Margie's kind of opening statements. Happy to be speaking with you, and thankful to National Lab of the Rockies for having us. So as Margie had just described, this substantial growth in Indian country is also, you have to grow your utility operations, and utility operations have to extend to make these, new businesses habitable, to make homes habitable. And these types of utility operations are ones you're probably familiar with, such as like energy, be it electricity, gas, propane, or other forms of energy, water and sewer utility operations, telecommunications, solid waste, and other assets or other aspects related to the operation of utilities, such as building codes, safety codes, and zoning. As we'll kind of go through today, tribes are increasingly taking control through providing, some of these utilities within their exterior boundaries of the reservations. So we have some fun facts here just to kind of get started. Some of these you may know, some of these you may have heard. Tribes must generally operate their governments without a traditional tax base, meaning that tribes don't typically collect tribal income taxes, so are generally forced to rely on sales taxes, taxing the provision of utilities and other things like that. Related to that, utility costs are often the largest monthly expense for tribal members, and utility services can't be deferred, and are health and safety issues. So this is not an avoidable cost. And these stack up, especially in really rural communities where electricity is expensive to distribute. That's something that tribal members kind of uniquely experience. Previously, most utility services were provided by third parties, but if tribes have developed over the last 25 years, as Margie was talking about, they're starting to take on some of these utility responsibilities. And we have some terms down here that you may be familiar with, such as self-governance, self-sufficiency, self-determination, and energy sovereignty. In our work, these kind of get treated as terms of art and are in a general, or they're either terms of art or they're very general descriptions. So these all, they have their own individual meanings, and we hope to kind of clarify on what some of that is on the rest of these slides. Next slide, please.
Yeah, thank you, Logan. Are there any questions on this slide before we move on? Or kind of any general questions that people may have?
We don't have anything in the chat yet, but please feel free to raise your hand or come off mute. We'd love to hear from you.
Okay, well, let's go on.
Yeah, and Margie would like this, just to say, Margie would also like this to be a bit of a conversation. So any question you have would be fantastic to hear. I know sometimes people have to scramble to find the mute button, so just giving folks an extra opportunity. And of course, even after we pass the slide, we can go back to it as well. So feel free to raise your hand or drop your question into the chat.
All
right,
well,
Margie, go ahead.
Okay. So the next kind of important definition to understand when you're talking about Indian tribes, Indian reservations are kind of a misnomer. The idea of a reservation is that when in the West, lands before they were owned by folks, when they were all federal lands, before the federal government would open those lands for homesteading or anything else, they would reserve certain parts of those lands for Indian tribes, for military purposes, and for many other purposes. And so a reservation comes from the reserved lands in the West that were reserved for Indian country. And of course, over the years, Indian tribes' reservations have been significantly eroded and their lands taken away bit by bit through historical activities. And so anymore, to understand what we're talking about is the term Indian country. And this is a term that's defined in federal law. And it says all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. So that basically means, the reservations. And of course, in the East, the lands were not reserved for Indians because this was really a Western concept. But nowadays, they do call them reservations. And then B is all dependent Indian communities within the borders of the United States, whether they are within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. That typically refers to Alaska, but can refer to other places. And then C are all Indian allotments, the Indian titles to which have not been extinguished, including right-of-ways running through the same. So the concept of an Indian allotment comes from the General Allotment Act of 1887. And as I was mentioning, there were historically reservations created that were very large. And for example, the entire state of Oklahoma was at one point an Indian reservation reserved for a number of tribes that had been moved to Oklahoma from all over the country, plus tribes like the Osage Nation who were there all along. As the population of the United States moved west, more and more people wanted those lands. And so what they decided to do in the General Allotment Act of 1887 was to issue an allotment to every Indian that was living there at the time. So if you were a male Indian, you received 160 acres, and if you were a female head of household, you would receive 80 acres. And then all the other lands that were irrigable and that were not issued to a particular Indian were opened up for homesteading or other use by farmers and people that wanted to move in. So if anyone has seen the 1990s movie Far and Away with Tom Cruise, where they all stand at the border of these lands, and there's people on horseback and people running and people in wagons, and then somebody blows a whistle and everybody runs out and they grab the land. Well, those happen typically after Indian land was allotted, because then all the extra land was open to homesteading. So due to that, there are many types of land in Indian country. There is tribal trust land, and these are federal lands held in trust for the benefit of the Indian tribe as a whole. And oftentimes these are the lands that were not considered irrigable or were not suitable for agriculture. So oftentimes they were mountainous or desert or something that they were not able to allot. Then there is the tribal fee lands. And these are lands that the Indian tribes have purchased back or otherwise acquired, and have bought, just like anybody can buy lands and own it in fee. And so tribes are more and more attempting to buy back lands that they lost over time. Then there are those Indian allotments, and these are the federal lands held in trust for the benefit of the sometimes numerous tribal Indian and sometimes non-Indian owners. And so what has happened over the years is that back in 1887, when these lands were allotted, a particular Indian received that allotment of 160 acres. Well, oftentimes, and most of the times, those people did not have wills. And so as they passed away, their lands then were passed by inheritance to all of their descendants. And more, those descendants sometimes didn't have the requisite amount of Indian blood to be considered a tribal member. So now oftentimes any particular allotment can have hundreds of the descendants of the original allottee owning those lands. And so that has really been a problem in Indian country as to how they administer their lands, because oftentimes it's very hard to manage lands that have all these numerous owners. The next type of Indian land is Indian fee. And these are fee lands that are owned by a particular tribal member, not by the whole tribe. Then there's non-Indian fee, and these are the lands within Indian country that are owned by non-Indians. So could be the descendants of the Tom Cruise character. Then the last one are easements, rights-of-way, leases, and other property rights that people have acquired in Indian country over the years. We use the term checkerboarded, which means when lands within a reservation are checkerboarded with tribal fee allotted in other lands, the jurisdictional analysis is different for each of these types of lands, depending on what's going on. So one of the things I will say is that every Indian tribe is different. And so, for example, on the Navajo Nation in Arizona, Utah, and New Mexico, it's not very checkerboarded. Because most of that was desert land, and it wasn't irrigable, so they did not allot a lot of it, although some of it is allotted. So you will find some reservations that are fully checkerboarded and some reservations that are completely still held in tribal trust. So each Indian tribe is very different in both their land base and in their government. So again, I'll stop here and see if there's any questions.
Margie, there is one in the chat. It's really more about the previous slide. Michael asked, without the tax base, how do tribes fund government operations?
Yeah, and that's a really great question. And honestly, that is the reason for, or one of the reasons anyway, for the huge tribal poverty that we have seen for so many years. The tribes have been really reliant on federal law and federal, excuse me, federal funds. Of course, in a lot of the treaties and a lot of the agreements made with tribes and the federal trust responsibility, the federal government has had to, in fact, subsidize a lot of tribal governments. That's one of the reasons why the casinos have been such a boon, and other opportunities that have been created for tribes in economic development over the years, and why it is so important that tribes are treated as governments in those kind of economic development areas. That has allowed tribes to own their own businesses and contribute to their own economies and create an opportunity for tax bases.
I'll also mention that one thing that is not necessarily widely known is that tribes, as their own governmental entity, are not required to pay state taxes. And that can happen in utility bills and other ways. So it's important to kind of keep that in mind as well. We have another question from Jennifer. Are tribal trust lands available for sale by tribes or tribal members?
No, they're not. And the reason they're called trust lands is that they're actually lands owned by the United States of America, held in trust for the tribe or the particular Indian. And so they're federal lands, just like, you know, a national park would be or something. And the term trust, and I think we're going to go through this in one of the next slides, is just like if you, you know, had a wealthy family and they put their funds in trust for their next generation. That's exactly the same type of legal basis for the lands being held in trust. The federal government has a trust obligation to the beneficiaries of the trust to make sure that the lands are held and managed only for the benefit of the tribes who are the beneficiaries of the trust. So they cannot be sold. The tribal fee can be sold, but the tribal trust lands cannot.
Thank you, Margie. Any other questions at this time? I don't see any in the chat, and I don't see any hands. So Margie and Logan, please keep going.
Okay. Okay, so I'll talk a little bit about the federal tribal relationship here. And we just did talk about the federal trust responsibility. This responsibility is grounded in treaties and statutes and expressed in federal case law. Trust, the trustee beneficiary relationship, as I mentioned before, is just like any other kind of financial trust that you would find in the banking industry. The resources that are held in trust are not just land, but they're also all natural resources such as oil and gas, such as water, such as timber, and any kind of minerals or anything else that would be within Indian country. Many tribes have treaties, and of course, many tribes do not. The tribes that have treaties are generally those that were at war with the United States. And the wars were actually stopped through the use of treaties. Treaties have the force of statutory law, and of course, different tribes have different treaties. Many tribes that don't have treaties were created by federal executive order. That the tribes weren't created, but their land bases and their governments were created through other means rather than through the treaties. But the treaties, the tribes that do have treaties have another layer of laws that must be applied. And I won't go into it here because it's very complicated, but I'll just say that Alaska is different. So because Alaska was not made a state until long after much of this history happened, they have their own set of laws that govern all the Alaska tribal natives. Logan, you want to talk about federal Indian policy?
Yeah, sure. So, as we've kind of talked about and alluded to, historically, the federal Indian policy, or the United States policy towards Indians in the country has been historically paternalistic and largely destructive, and it's been unsuccessful for tribes and for society generally. We often see kind of shocking poverty statistics around tribes, kind of shocking substance abuse statistics around tribes. These all stem from the federal government's treatment of tribes since the USA has been a country. Since 1961, the federal policy has generally been self-determination with an emphasis on tribal resurgence and governance. And a great example of that is the 1975 Indian Self-Determination and Education Assistance Act, which are referred to as PL 30, or I don't know what the number is, but 638 contracts. This is a great kind of example of the transition away from paternalism and into focusing on tribal self-determination. So 638 contracts generally allow tribes to plan and operate and control programs that have historically been offered by the federal government, such as healthcare programs, education programs, and law enforcement, just to name a few. 638 contracts allow tribes to step into the shoes of the federal government, fund these programs, and allow tribes to operate them themselves. Easements and rights of way in Indian country, that's always kind of prescient factor in utility development in Indian country. Those are governed by their own set of CFRs. Federal Indian resources and rights, they exist both on and off reservation. So as Margie was talking about, different tribes have different treaties. Some treaties grant tribes off-reservation hunting rights. Some treaties do not. And that plays out all over the country in different ways. And that's where you have to really kind of look to assess, what rights does this tribe have to self-governance? A lot of those derive from the treaties. And then, yeah, so I guess here is a good sort of rule of thumb. When states deal with tribes, they're often dealing with federal matters. And a good way to deal with or think about that is ask, could the state do this act on federal military base or on other federal lands within a state as a way of sort of thinking around the different jurisdictions?
Are there any questions or shall we keep moving?
I do not see any in the chat. So I think we can keep moving on.
Okay, so there's a lot of times when you work in Indian country, you hear the word sovereignty, and it's hard to know what that means. Sovereignty is basically the act of being a government. Tribes have inherent tribal sovereignty. This kind of sovereignty does not derive from the United States or from any other act of Congress or any other body within the US. Federal law acknowledges that tribal powers stem from tribal rights that have never been extinguished from times before the United States of America was in place. So tribes act on their inherent tribal sovereignty. Tribal powers include the right to determine the form of their own government, to determine who their members are, to legislate and tax, the power to exclude persons from their tribal territories, and the power to administer justice. So each tribe and each reservation is going to be subject then to a completely different tribal council. Oftentimes, that's how these days most tribes govern themselves, is through a tribal council. And oftentimes those tribal councils are elected pursuant to a constitution that is specific to that tribe. Then oftentimes the tribe will pass their own laws. So if you're working with two different reservations within your state, the tribal constitutions may be different. Certainly they will have different governing bodies, and they will have different laws that apply in those reservations. Logan, you want to talk about sovereign immunity?
Yeah, so sovereign immunity is a term everyone's probably familiar with, and it's applicable to tribes as well. So sovereign immunity refers to immunity from suit. And as I, just described, it's a well-established feature of sovereignty for all recognized governments. The government may not be sued without its consent. And for tribes, uniquely, it applies within or outside of tribal lands. It applies to commercial and governmental dealings and for governmental purposes. And it applies without regard to whether the actions are subject to state jurisdiction. And from that, from sovereign immunity also stems the right to write and legislate for the common welfare of the tribal community, and that results in tribal laws. So tribes can make an example of that would be that tribes can make utility laws. They can form utility commissions to regulate utility matters. They can franchise utilities, assessing franchise fees on utilities. and they can determine and engage in eminent domain practices through written policy and procedure. Just as a state has sovereign powers within its jurisdiction, so does a tribe.
Any questions?
None in the chat. Great. So thank you, and keep on going.
Okay. So if you're a state working on some kind of an issue that relates to a tribe, the first question you might want to ask is the jurisdiction federal or local? Because when you're working in utility industries, the federal government has essentially jurisdiction over all wholesale matters, where the state or the local tribe may have jurisdiction over the retail matters. So the first question is really looking at whether the federal government has jurisdiction over that energy, telecom, or water activities or other activity. Generally, under the 10th Amendment in the Constitution, anything not federal is state, or if under Indian jurisdiction, then it's tribal. Unless it's statutory, tribes, tribal businesses, and tribal members have the same federal obligations as states and others. The notable exception is that tribes, like states, are not federally taxed. Tribal members are federally taxed unless the income results from federally held trust resources. So for example, if a particular Indian allottee has forested lands and they use the forest for some purpose and a payment is made, that is exempt from federal tax. But otherwise, all Indians pay taxes just like all other citizens of the country. Logan?
Yeah, thanks, Margie. And so tribal utilities are businesses doing business in a manner that is federally regulated. They have to be familiar with federal law and federal regulation, specifically if a tribe's wishes to build or own a federally jurisdictional facility, which would include managing wholesale power loads, managing hydroelectric dams, transmission, or power generators that are connected to the grid. Just requires tribal utilities and businesses to understand those federal laws and regulations. And relative to energy and tribal governments, FERC, the Federal Energy Regulatory Commission, has acknowledged that tribes are governments and not public utilities, which are generally for-profit entities under the Federal Power Act.
And we do have a couple questions. Oh, yeah, Jenny has her hand up, and she has a question about sovereign immunity. Go ahead, Jenny.
Hello, this is Jenny Singbach with NYSERDA, which is an energy agency in New York. Sovereign immunity issues have come up with some of our indigenous nation partners who built solar projects that they tried to connect to the grid, and the private utility that they needed to have an agreement with to connect to the grid asked them to waive their sovereign immunity in order to connect their solar project to the grid, and the nations refused obviously to waive their sovereign immunity. And I think I'm just asking if are there best practices where nations have figured out a way to connect to the grid, factoring in their sovereign immunity and like working with utilities?
Yeah, I think it's really common in Indian country for a limited waiver of sovereign immunity. I think all tribes know that, if they enter into a contract with someone, that contract needs to be enforceable. And so generally there is a limited waiver of sovereign immunity, and the limits are generally specific as to how they're what rights are being waived. So obviously if the tribe is going to buy something from somebody and the tribe needs to pay money for it, they need to waive the right to have somebody collect that. So you have to be really, tribes generally aren't going to do just a blanket waiver of their sovereign immunity, just like a state wouldn't, or just like the federal government does not generally just waive its sovereign immunity. It does so only in specific ways. So there are really common uses of limited waivers of sovereign immunity.
Got it. Thank you.
Great. We have another question from Madeline. How would eminent domain work if there is fee land and trust land?
Yeah, so the question is whether the land is within the jurisdiction of the tribe. So if the tribe has jurisdiction, if it's in Indian country and the tribe's jurisdiction extends to the fee land, then the tribe has the right of eminent domain. I don't think any tribe has ever tried, like, for example, if you're a tribe in Arizona, it would be very hard for that tribe to be able to acquire land in Wisconsin, because it would have to be used for a tribal purpose. So generally, it's within an area in which the tribe has jurisdiction. And so just like a state can take fee land, or a state can take property that is belongs to someone else, a tribe can do the same. I will say that as far as real property rights go, as far as land goes, if a tribe were to attempt to take land or real property, that they would have to do so in federal court, because again, lands that are trust resources or that are related to trust resources, or that are going to be put into trust, that is federal land. And so you can't manage federal land in a tribal court. Oftentimes, the tribal eminent domain rules relate to personal property. So for example, if a tribe is starting a utility and there are utility facilities owned by a third party on the reservation, and the tribe wants to acquire those facilities, the tribe can basically take by eminent domain all of those personal property rights. If that utility owned real property rights, like an easement or a right-of-way that those facilities, sat on, the tribe could not take those real property rights without doing so in federal court. And the way the tribe would do that is to go to the district attorney in the state, the federal district attorney in the state where they're seeking the action, and they would file on behalf of the tribe. I don't have many examples of that ever happening, but that is, I'm told, how it would be done if there was an attempt to take a federal trust resource. Did that answer your question, Madeline?
Yes, thank you.
Great. Any other questions on this slide? Not. Take it away, Margie and Logan.
Okay, so once it's determined that it's not a federal issue, and an example of how it would be a federal issue, and one that's often confused, is that if a tribe is forming a utility and they're taking a third-party utility's infrastructure, and then they're going to interconnect with that utility to serve a new tribal utility, that would be a federal issue because it's a wholesale matter, and you're basically doing a wholesale tariff to serve a wholesale utility. If it was a state issue, then it's a little different. Then that would be something that was not a wholesale matter, but a retail matter. So this then gets very, very complicated. The next issue about whether it's a state or a tribal jurisdiction will depend on where the activities takes place, who is involved in the activity, and the types of interests at stake. And this goes back to those different types of lands And so if a tribe is acting within their trust lands, then it's very clear they have the right to fully regulate. If it's not on trust land, if it's on non-Indian fee land within a reservation, then there are balancing tests that the Supreme Court has told us we must apply. And so I don't think we're going to necessarily go through all the stuff in the green over here. Can the tribe exercise jurisdiction? Because basically the court has laid out a number of really complicated balancing tests to determine whether the tribe has exclusive jurisdiction or the state has some jurisdiction, or if there's actually a combination of jurisdiction on the matter. So you would have to consider the jurisdictional statements in the tribe's treaty. You would have to consider the tribe's constitution, tribal laws and ordinances, tribal council resolutions, and other government documents. In some cases, you also have to consider the state constitution or state law, because some states basically just relinquish jurisdiction by certain laws or by case law. So I'm not sure. Logan, why don't you go through and just give some examples here in the green about how this would work?
Yeah, so I think, Margie mentioned, sometimes the question of who has jurisdiction to operate within Indian country is a complicated one. And sometimes it's found to be both, a tribe and a state. And the Devil's Lake Sioux Indian Tribe versus a North Dakota Public Service Commission case is an example of that. There's the issue, or basically it was held that the issue of tribal jurisdiction over utilities on reservations is a federal question. But that related to a state's attempt to regulate an on-reservation utility or a non-tribal utility on a reservation. And then I guess on trust and tribally owned lands, you have the Worcester v. Georgia case, which is kind of the last case in a series of really early Supreme Court cases known as the Marshall Trilogy that set out a lot of the federal common law and court decisions that follow. There, it was held that tribes have plenary and exclusive power over their members and their territory, subject only to the limitations imposed by federal law. And then I guess another wrinkle in the who has jurisdiction question always comes up with regard to a tribe's authority to regulate non-members in Indian country. I guess the Supreme Court has batted this issue around quite a bit over the years, and then in 1981 had come up with a test for determining whether a tribe can regulate the activities of non-members. And the test is basically, it's a two-factor test. The first factor is, a tribe may regulate the activities of non-members who enter consensual relationships with the tribe or its member through commercial dealings, contracts, leases, and other arrangements. And two, a tribe may retain inherent power to exercise civil authority over the conduct of non-members when that conduct threatens or has some direct effect on the political integrity, the economic security, or the health and welfare of the tribe. And that's where you can kind of see some remnants of the Worcester v. Georgia decision in the deference to tribal integrity or political integrity.
Yeah, and so we can argue, I think, pretty well that for utility matters, if it's a water utility or an electric utility, that the tribe still probably has that inherent jurisdiction to exercise the civil authority over that conduct, because utility matters definitely directly affect their economic security and their health and their welfare. And so as far as utility matters go, it's a very strong assumption that tribes have the right to regulate the utilities within their reservations or in Indian country. And that has played out a couple of times in a number of cases. And most of the times when they have, the cases have weighed out these factors, they have found that the tribes have the right to regulate exclusively on their lands, whether it is an entity, a third-party entity doing business on tribal lands, such as a utility, or whether it's their own tribal utility. And the state does not have the authority then to do that, to have regulatory authority on the reservation. It's complicated, though, I will also say, because in fact, the state regulators have generally regulated the entities, and I think we're going to talk more about that in the next slide, but we'll pause here for questions. Or Logan, did you have something else?
Yeah, I was just going to add to that and kind of relating it to utilities and the assumption of tribal control within a reservation. That assumption gets even stronger when you're talking about a tribe's ability to regulate a utility serving tribal facilities or tribal businesses. That becomes a very strong presumption in favor of the tribe in that context, as opposed to just random, facilities or homes within the exterior boundaries. It's a very strong presumption when the regulated activity is related to utility service of tribal businesses and tribally owned facilities.
So I'm sure that was clear to everybody. There's probably no questions, right?
Jenny has her hand up. Go ahead, Jenny.
Hello again. And Pilar, thank you. We're Shara, our new Indigenous Nations liaison from our team, and I joined the DC workshop. So this is all great information. And I know our Shinnecock Nation partners are on here. Hi, Philip. One of the issues we've been trying to work through is this gray area where nations have their authority to regulate utilities on, right, like you just said, but some don't have capacity, I guess, like they don't have their own energy commission or things like that. I mean, they have to be like a tribal government that would regulate the utility, but there's often instances where a private utility that's servicing them, they run into issues with them. And like, I think sometimes it has worked out that our New York State agency that regulates private utilities has, like, nations have asked, I guess, have reached out to, like, say, how do we resolve this issue that we're dealing with, like, for example, National Grid, and like the state regulator comes in as kind of an arbiter, even though, they don't have the authority to regulate on nation territory. So is there any like best practices for if a nation doesn't have capacity to regulate utilities, like what happens? How can the state support in that instance?
Yeah, I mean, it's really complicated because the states generally have jurisdiction over the utility. Right. They just don't have jurisdiction over the utility acting in Indian country. Mm-hmm. But generally the utilities apply the state rules in Indian country simply because there aren't any rules from Indian country, or at least not often. So some of the best practices then have been that if the tribes don't have the capacity, they basically say the tribe will adopt the state rules until such time as the tribe decides to have some other law that is passed. So they're not then kind of just relinquishing their sovereignty. They're saying we're going to adopt the state's laws as the tribe's laws in the meantime. And then at some certain point, they may say, well, we don't agree with this particular this particular state rule. So we're going to then adopt something different for the tribe. So that's something that's been done in the past. But yeah, it is, a lot of the tribes are very small. We have clients that are, tribes that are only 300 members. They don't have the expertise, and they don't have even the number of people necessary to man, complicated utility commissions that are going to look at, very complicated rate issues and that type of thing. So just kind of as a de facto measure, they've oftentimes relied on the states to help. But the real rub comes when the tribe tries to regulate and tries to do things on their own lands using their own utility authorities, and someone comes in and says, well, the state won't let you do that. Well, that's really not true, because the tribe can kind of subvert the state's authority if they wish.
Thank you. That's helpful.
All right, next slide, please. So here's the question about can the state exercise jurisdiction? As we've said here just now, almost all reservations have third-party utility companies providing services to the tribe and to the tribal members, and there's generally a de facto application of state rules by the utilities to their tribal customers on Indian lands. So the most recent federal case that's come out was the McGirt decision in 2020. And even though this was a criminal law case, it really did apply some pretty broad language. And so in that case, it stated the policy of leaving Indians free from state jurisdiction and control is deeply rooted in our nation's history. And then it cites some cases. Chief Justice Marshall, for example, held that Indian tribes were distinct political communities having territorial boundaries within their authority and within which their authority is exclusive, which is not only acknowledged but guaranteed by the United States, a power dependent on and subject to no state authority. And of course, in many treaties, the federal government promised Indian tribes the right to continue to govern themselves. So it is still a very kind of sure thing that tribes have the right to regulate, at least on the trust lands. Do you want to talk about White Mountain Apache a little bit, Logan?
Yeah, so White Mountain Apache kind of gave a two-part test to determine whether the state is preempted from exercising jurisdiction in Indian country. So the first part of that test is, an analysis of whether the exercise of state authority may be preempted by federal law. And then the second factor in that test is the application of state laws or regulations may infringe on the right of reservation Indians to make their own laws and be ruled by them. So in Margie had just kind of described a balancing test. That's where this is, where it becomes a balancing test. So in making that decision of whether the state has been preempted, or if the exercise of state jurisdiction could be defined as infringement, the courts have balanced the federal interests in kind of comprehensive sets of laws, also the trust responsibility to tribes, a tribe's interests in economic development and self-governance and self-determination, and then a state's interests in the particular regulation and related to the matter. And where it comes up a lot is a state's ability to basically collect taxes in Indian country. So a review of the relevant state laws, including the state constitutions, is also important, as many states limit interactions with Indian tribes.
Any questions? All right, let's go to the next one, please. So we were saying earlier that state taxes is a kind of a clear line. State taxes, including utility taxes and state programs, which amount to taxes, may not be collected from tribes or from Indians living on reservations. So here's some cases that describe that. Utility taxes can also be rejected based on tribal sovereign immunity. So if someone tried to sue a tribe to collect taxes, the tribe could say, we have not waived our immunity, and so you can't sue us to have that paid. So here's some cases that talk about that as well. And many states make this easier by having a form that a tribe or a tribal member living on a reservation fill out and send to the utility or to the taxing entity. Because of course the utility doesn't know on the reservation who's an Indian and who's not. So they have to have some way of getting notice that they should not be collecting tax. So I know, like, for example, California has that type of a form, so does Kansas, and I'm sure a number of other states do as well. Any questions?
It looks like Jenny has her hand up.
Hello again. Feel free, anyone else, to jump in, but I think I asked this a little in the workshop, but I just want to follow up to get your legal opinion, Pilar. So does in New York State, a lot of our energy programs are funded by a surcharge, a systems benefit charge that's on utility bills. Would this be considered a utility tax?
You know, it very well could be. We run into this issue a lot in California as well because they have a number of programs. I think that there could be an analysis done to determine whether or not that was a tax. And there's another whole body of law out there that helps people determine when something is a tax or when it's a fee. And so you would have to look to your local law as to that question. I guess one of the other things is the tribe taking advantage of that program? So many times the tribes are not taking advantage of those programs. And if they're not, then maybe that's just a tax to them that, you know, they get no benefit from. So I guess, you know, that's another whole legal analysis you'd have to go through to determine whether those are also taxes.
Got it.
Next slide, please. Oh, well, that's the last of the slides. Are there any other questions that people may have about Indian country generally, or the utility matters we've talked about here, or any other kind of general questions? We're happy to answer.
Jenny has her hand up.
So a follow-up question to what I just asked, and then another question. If the programs that are funded by the systems benefit charge that is on utility bills, the programs are intended, a lot of them are intended, and nation residents are eligible for the programs, but I think because of a lot of other issues, we haven't had a good history or track record for nation residents actually enrolling or receiving benefits programs, but a lot of them, they could benefit from them. So does that make a difference? Like, to make it a fee versus a tax?
Yeah, I mean, that would be kind of an example of a good question for government to government consultation. You know, for example, if the state was willing to say, well, we're going to take this charge off of the bills that are sent on reservations if the tribes don't want to participate. So, you know, you wouldn't want to just remove those charges from the bills, because then the tribes would not be eligible for them.
Right.
But you could always, if you wanted to, or the tribe could maybe come to you. That's another example of good government to government communication. If the tribe came to you and said, look, we're never going to apply for these funds, we want you to stop charging them on our reservation because we believe they're a state tax, that would be, you know, fruitful ground for a government to government discussion.
Got it. And I have a question about tribal utilities, but I'll pause because I see Philip has his hand up.
Yeah, Philip, go ahead.
Jenny, if you want to ask your question, you can. You can ask first, and then I'll follow.
Okay. I just wanted to know if there's resources for like, or examples of indigenous nations out there that have successfully created their own tribal electric utility, that there's like reports on that or anything for us to learn about best practices.
Yeah, there's some really good reports. The Western Area Power Administration did a report. It's a case study of 5 of the tribal utilities. It's kind of an older report now. I think it was done in like 1996 or something, but it's a really good report. And then it was updated again in the like 2000 and something, I don't know. But it does have good case studies on some of the earlier formed tribal utilities, and mostly those were ones that were formed under 638 contracts when there was previously a BIA utility and the tribe took it over, and then kind of how that tribal utility was formed. There's a really good white paper done by the Cow Creek Band of Umpqua in Oregon about how they did their utility. So yeah, and I understand that that WAPA report may be being upgraded or updated by the National Lab of the Rockies coming up here in the future at some point. So yeah, there are some good good resources out there. I don't have them all at my fingertips right now, but I think we can have those. Carlin, can we have those put on a site someplace where people can access them?
Yeah, I think that's a great idea. One of the things we would like to have, and we're still in the process of building, is a resources page. So yes, it'd be great to get those and put them on the resources page on our website.
Yeah, and Jenny, if you want to just email me, I will send you some links. That'll be an easy way to do it. And I think my email address was on the first page of this thing, if we want to go back to that.
Okay, thank you.
Philip, go ahead.
Okay. Yeah, and thank you. This is a great, actually, forum. And I want to thank Jenny for first reaching out and inviting a couple of us to it. She invited myself and Christian, who is the head of our Shetty
And Philip,
yes.
I'm sorry to interrupt. It's hard for me to hear you. I don't know if it's just me.
Okay. Can you hear me now? Is my mic low?
We can hear you. It's just
it's
kind
a
of
little
blurry.
bit better. Yeah, it kind of seems like you're on a speakerphone and sitting far away from the microphone.
I'm sitting pretty close, actually. Hold on. Let me see if I can get my. Can you hear me now? Can you hear me louder now?
Ooh, for a second it was good, and then it kind of went back to tinny.
And then I went back to skinny.
Yeah.
Okay. All right.
We can hear you like good enough. It just sounds a little, low quality, but we can hear you.
Okay. As far as I know, like New York is not far along. As far as long as like California, New Mexico, and Minnesota, as far as state tribal relations. But I know NSERDA has really done a good job with coming and reaching out to us and sitting down and talking with us. So I hopefully by Jenny attending some of these meetings and bringing that feedback back to the governor and Noreen, the head of NYSERDA, that New York will start looking at those type of relationships with our tribe as well when it comes to utilities in the state. But under NYSERDA, we have a number of people that have worked with different companies to come in and put in these new HVAC systems. And does that surcharge go for those rebates on those systems, Jenny?
Well, it depends if it's the Long Island utility, the Long Island Power Authority, if it's a program that is managed by them to install HVACs, or if it's a NYSERDA program.
No, it's one of NYSERDA's.
It's one of NYSERDA's.
It's one of NYSERDA's partners, like the Green Team, one of the partners.
Yeah, it likely is. It's probably that program is likely funded in part from the systems benefit charge and partly from other funding.
Okay, all right. So you guys are, you guys are. We're getting some of the benefit from that, but thank you for bringing that to our attention. And we'll be reaching out to you guys to figure out how we can make better use of that. But thank you for this forum. It's a great forum.
Yeah, and I mean, to follow up on that, I would say just that is a perfect example of, it's always helpful when you know that your state or a state agency like NYSERDA has programs that you may be eligible for, whether it's government to government or just creating a relationship with them. I would encourage, tribes and utilities and tribes and states to reach out and talk to each other, because there are always programs and opportunities and ways to partner together that can be worked out. But it really does take a conversation. And I will say that, for so many years, tribes always felt a little bit like all these outside entities were hostile to them. And it's now getting to be more and more that we're all here to support and help each other. And so let's take advantage of each other's knowledge and programs, and establishing those relationships is really a way to reach success. And by doing this kind of through lawsuits and trying to create laws and different things like that is the difficult way to do it. It's much easier to reach out a hand and figure out how you can work together on these projects, because there's oftentimes fertile ground for that kind of success.
Great. I don't see any additional questions in the chat. Nobody else has their hand up. Any other questions at this point? Okay. If not, then we can get to some of our last slides. So, as mentioned, and I put it in the chat as well, on our project website, we do have the resources that I was mentioning. We have 3 recorded webinars. Today's webinar is recorded as well, and we will add it once we get the transcripts and whatnot. But certainly feel free to look back on the other webinars. There are workshop materials, which is the full PowerPoint presentation that was delivered in Golden, Colorado, and Washington, D.C. While we covered the same material, depending on the questions that were asked in the audience, we did cover different ground. So and we had different speakers as well, so their slides are a little bit different. So there's great examples in both of those. And then we have our 6 fact sheets, which cover everything from State Tribal Energy Collaboration 101, tribal right to create laws, state role in the legal framework, how tribal entities govern business and commerce, types of tribal land, and tribal utility programs. These are overviews. They're not full papers. They're really only 1 to 3 pages long. They'll give you some good insight into the future direction. And then we have broader program activity as well. NLR has a state, local, and tribal government program that supports energy solutions across multiple types of communities. So you can, if somebody could, from the NLR team could drop this link into the chat as well, that would be great. Maybe Emma or Milana. But there are specific resources for states, for local governments and communities, for tribes, for islands and territories as well. And we definitely want to thank the following individuals and organizations for their inputs and process in this overall work that we have been doing. So Margie Schaff, Pilar Thomas, Kevin Blazer, the Alliance for Tribal Clean Energy, Midwest Tribal Energy Resource Association, Catherine Zing. And if you're not aware, Grid Energy Alternatives created a specific tribal energy alternative, and they have been very active in doing a lot of great work. Also Baker Tilly and Heather Rhodes. And I would also like to thank Logan for participating in this forum as well. So thank you all. Let's see if there's additional questions. So Milana, thank you for dropping the NLR State Local Tribal website and then the State Tribal Energy Collaboration webpage again. Any last comments or questions at this point? If not, we'll sign off and say thank you so much, everyone, for participating. I hope this was helpful to you, and we hope that we can be doing more of this kind of work going forward. Thank you, and take care.